On the 13th of February 2020, the Grand Chamber of the European Court of Human Rights rendered their long-awaited judgment in the case of ND and NT versus Spain. This was the first trial that addressed immediate expulsions, or pushbacks, at Europe's land borders, an unlawful but common practice. In its final judgment, the Grand Chamber found that pushbacks at the Spanish-Moroccan border in Melilla did not violate the European Convention on Human Rights. In doing so, the court introduced a new exception to human rights at Europe's borders, creating a dangerous precedent. The court stated that crossing the fence was culpable conduct on the part of the two claimants, ND and NT, because they should have used the legal entry procedures instead. The court accepted that Spain had provided to the applicants several possible means of seeking admission. In this video analysis, Forensic Architecture and the European Centre for Constitutional and Human Rights demonstrate that both Spain's claims and the court's conclusions are false, and that sub-Saharan nationals had no opportunity to seek access and admission into Spain. Using spatial analysis, official statistics, human rights reports, and testimonies of people who tried to cross the border, we demonstrate how Europe's system of structural racism operates. The case takes place in Melilla, one of two Spanish enclaves on the north coast of Morocco. Melilla and Ceuta have the only land borders between the European Union and an African state, marked by complex systems of fortifications composed of 3 tall barbed wire fences. On the 13th of August 2014, 2 men, ND from Mali and NT from the Ivory Coast, climbed the border fences surrounding Melilla. When they descended to the Spanish side, they were apprehended, handcuffed, and returned to Morocco through openings in the fence. 6 months later, ND and NT submitted a complaint to the European Court of Human Rights. They stated that they had been subjected to a collective expulsion without an individual assessment of their circumstances and in the absence of any procedure or legal assistance. In October 2017, the court condemned Spain for violating the prohibition on collective expulsion. However, at Spain's request, the case was referred to the court's Grand Chamber to be re-examined. And in February 2020, the Grand Chamber announced its final judgment, finding that Spain did not breach the convention in returning migrants to Morocco who had attempted to cross the fences of the Melilla enclave. The court declared that the applicants had several possible means of seeking admission, in particular, by applying for international protection at the Beni Ensar border crossing point, or in Spain's diplomatic and consular representations. First, we examined the claim that migrants could apply for protection at the Beni Ensar border crossing. Dozens of reports and testimonies demonstrate that sub-Saharan migrants are prevented from reaching the crossing itself.
Tout le monde aime aller demander l'asile, ne pas sauter la barrière là. Qui va vouloir aller sauter la barrière, ces 3 grillages, se fait tabasser, se fait frapper par la police, alors qu'il y a un chemin le plus court.
Abu Bakr Sidibe arrived in Morocco in 2013, hoping to reach the European Union.
C'est impossible d'aller jusqu'à la frontière et demander l'asile. Nous, un noir qui descend dans la ville déjà juste pour chercher à manger, nous sommes poursuivis par la police et les militaires marocains.
At the time of the incidents in August 2014, a sub-Saharan national who wished to claim asylum in Spain would have to evade the surveillance of the Moroccan police in the town of Beni Ensar, pass through 3 police checkpoints where access is systematically denied, and then reach and be accepted at the Spanish border post, where they could theoretically formulate an asylum claim. The distance between the first Moroccan checkpoint and the Spanish border post is more than 300 meters.
Ils nous attrapent, donc ils nous amènent au refoulement, soit à Rabat, soit à Marrakech, soit à Fès. C'est jamais nous donner l'opportunité d'approcher la barrière. Même s'il faut nous frapper, ils vont nous frapper. Même s'il faut passer par la force, ils vont passer par la force. C'est comme ça.
Journalists have documented the violence at Melilla's fences, both by Moroccan border guards and by the Spanish paramilitary police, the Guardia Civil.
Il est impossible pour une personne noire de peau d'approcher les postes frontières de Ceuta et Melilla. C'est impossible, elles seront arrêtées avant.
Elsa Tisler has researched human rights violations at the borders of Ceuta and Melilla for years.
À Nador, par exemple, à Beni Ensar, il y a des unités spéciales affectées à la traque des dits subsahariens. C'est quelque chose qu'on observe évidemment très facilement. Moi, je l'ai vu de mes propres yeux en allant régulièrement à la frontière, en allant dans les campements.
During her research, Tisler has also collected testimony from Guardia Civil officers. Yes, there are the whites and the blacks. Sub-Saharans cannot come over by foot, unlike the Syrians who use the border control post. This denial of access has been raised in front of the court and was underlined by the UN's refugee agency.
UNHCR is further concerned that access to the territory at the Melilla border crossing is in practice only available to persons from Middle East and North African countries. Access is virtually impossible for sub-Saharan Africans who are prevented from approaching the border area.
Nevertheless, at the trial, the Spanish representative to the court claimed that Spain did allow asylum claims at the Beni Ensar border post in Melilla before August 2014.
And we have furnished the data before 13th August 2014, which is 21 requested in police stations and 6 came from the border crossing.
However, these 6 alleged asylum claims at the border crossing do not appear anywhere in the evidence submitted by Spain. They are not in this report from December 2015 by the Melilla Police Directorate, which was specifically highlighted by the court. Nor is it in the list of all asylum applications registered in Melilla in 2014. We plotted this data on a timeline. In blue are the applications made at the Beni Ensar border crossing, and in red, those made on Spanish land, inside Melilla. We can see that, in contradiction with Spain's claim, not a single application was registered at the Beni Ensar border post before the 13th of August 2014, the day of ND and NT's pushback. The first applications at the border were registered only on the 20th of September, when Spain opened an Office for International Protection at the Beni Ensar border post. Plotting all the asylum claims made there from the opening of the asylum offices until May 2017 reveals the patterns over a longer period. The locations of these circles indicates an applicant's recorded country of origin. The size of the circle indicates the number of applications. As we can see, 99% of the claims came from the Middle East and North Africa, now highlighted in green, of which most were Syrian. Only 2 claims by sub-Saharan nationals were registered in this time frame, now highlighted in orange. An investigation by the Spanish media outlet El Diario revealed that these claims were made by 2 women who managed to avoid racial profiling by wearing traditional Moroccan clothing. No other claims by sub-Saharan nationals were registered. This bar chart shows the distribution of asylum claims. The claims made by sub-Saharan citizens are a minuscule fraction of the total. Spain's assertion about the option to claim asylum at the Beni Ensar border post is thus false. Sub-Saharan nationals lack access to asylum at the border, both before and after the opening of the Office for International Protection. Ceuta, the second Spanish enclave in Morocco, also does not offer legal routes to claim asylum. In fact, there has never been an asylum claim registered at the Ceuta border post. The second claim that we investigated was the court's assertion that the claimants could have applied at Spain's diplomatic and consular representations. The court pointed in particular to the Spanish consulate in Nador, given its proximity to Beni Ansar.
Quand j'écoute quelque chose comme ça m'énerve. C'est comme jouer avec l'esprit des gens. C'est de se foutre de l'être humain que nous sommes. Dans la région de Nador, les migrants subsahariens sont interdits d'y être.
C'est impossible pour une personne noire de peau de marcher tranquillement dans Nador. Elle va immédiatement être arrêtée, interrogée et assez vite arrêtée et emmenée le plus loin possible de la frontière.
Spain provided the court with data on applications made in its embassies and consulates. The consulate of Nador does not appear anywhere. The data on Morocco covers only the embassy in Rabat and the consulate in Tetuan. However, the claims recorded there are only from Syrians and Moroccans. Not a single claim was made by a sub-Saharan national between 2014 and 2018. Moreover, these numbers are only registered applications. There is no evidence of whether these claims have ever been granted or even examined. This is clearly formulated in an official letter by the Spanish government to all ambassadors. The fact that someone seeks to lodge an asylum application with an embassy or consulate does not, in any circumstances, entail the start of a procedure for possible admission. At the trial, the UN Refugee Agency confirmed this.
No procedure for seeking international protection in a Spanish consulate or embassy has been established or applied for, except for family reunification purposes with recognized refugees in Spain.
Thus, the court's conclusion that the claimants could have applied in Spain's diplomatic and consular representations is also false. Spain made misleading claims, contradicted not only by multiple reports and testimonies, but also by their own evidence. Nevertheless, the court accepted these arguments and dismissed those of the claimants. The resulting judgment is a gross distortion of the facts. To deliver justice, the European Court of Human Rights must acknowledge the reality at Europe's borders, and not base its conclusions on false assumptions. This investigation shows that no legal pathways to enter Spain were available for the claimants as black migrants from sub-Saharan Africa.
Il faut comprendre qu'à cette frontière, il y a vraiment une question raciale. C'est-à-dire que votre appartenance ou votre catégorisation ethnique raciale va modifier la façon dont vous allez avoir l'expérience de cette frontière-là. Le passage des barrières, cette technique-là, elle est née de la traque raciste, de l'ordre migratoire raciste qu'il y a à cette frontière. C'est un acte de résistance.
Moi, je vais être clair et je vais être clair dans mes propos. C'est du racisme, voilà. Et rien d'autre que ça, quoi.